the Supreme Court case that could decide the future of AR-15s. A shocking court decision just opened the door for states to ban the most popular rifle in America. And now, the Supreme Court has to step in and answer one simple question. Does the Second Amendment actually protect guns that millions of Americans legally own? Let me explain what just happened and why this matters so much. What this case is about. A lower federal court just made a stunning admission. They openly said that AR-15s and standard magazines are owned by millions of law-abiding Americans. They acknowledged this fact in their ruling. But here's the problem. Even after admitting this, they still said Connecticut could ban these firearms completely. Think about that for a moment. The court agreed these guns are commonly owned. They agreed they're used legally. But they said the state can still ban them anyway. Why? Because the judge decided they're too dangerous. This case is now heading to the Supreme Court. And the question they're asking is critical. Does the Second Amendment protect commonly owned firearms or not? The Supreme Court's previous guidance. Here's why this lower court decision is so problematic. The Supreme Court has already given clear guidance on this issue. In two major cases, Heller and Bruin, the Supreme Court established a test. They said that firearms in common use for lawful purposes are protected by the Second Amendment. This isn't complicated. It's actually very straightforward. If a gun is commonly owned by Americans for legal purposes, it's protected. That's the test. But this lower court just ignored that test completely. They created their own standard instead. They decided that even if a gun passes the common use test, judges can still ban it if they personally think it's too dangerous. This completely undermines what the Supreme Court said, the Connecticut law being challenged. Let's talk about what Connecticut actually banned. The state law prohibits the sale, transfer, and possession of AR-15 style rifles. Connecticut calls these assault weapons. The law also makes it a crime to possess or transfer magazines that hold more than 10 rounds. The people challenging this law argue that these bans target arms that are clearly protected. AR-15s are bearable arms. They're widely owned across the nation, and they're used for completely lawful purposes like self-defense, training, and sporting activities. These aren't unusual weapons. They're some of the most popular firearms in America. How this case reached the Supreme Court. Here's the path this case took through the courts. The plaintiffs filed their challenge in a federal district court in Connecticut. They argued that the rifle and magazine bans violate the Second Amendment. They asked the court to block enforcement of these laws while the case proceeded. The district court denied their request. The court concluded that the plaintiffs would probably lose their case on the merits. So the plaintiffs appealed to the Second Circuit Court of Appeals in August 2025. The Second Circuit reviewed the case and affirmed the lower court's decision. They also denied the request to block the law. Now here's where it gets really interesting. The Second Circuit's shocking reasoning. The Second Circuit Court made an extraordinary admission in their ruling. They essentially agreed that AR-15s and the magazines in question are in common use. They didn't dispute this fact. But even after agreeing to this, they still upheld the bans. How did they justify this? They twisted the Supreme Court's previous rulings. The Second Circuit claimed that even though the Supreme Court said weapons in common use are protected, that's not really what the Supreme Court meant. According to them, the Heller decision doesn't actually shield popular weapons from being banned. Instead, they created a new test. They said courts can look at whether weapons have an unusually dangerous character. And if judges decide a weapon is unusually dangerous, it can be banned regardless of how commonly it's owned. This is a direct contradiction of Supreme Court precedent. The interest balancing problem. There's another major problem with what the Second Circuit did. The Supreme Court in Bruin explicitly rejected something called interest balancing. This is when courts weigh the government's interests against Second Amendment rights. The Supreme Court said very clearly, don't do interest balancing. But the Second Circuit did it anyway. They just disguised it. They claimed they were doing a historical analysis, looking for historical analogs to justify the bans. But that's not really what they did. Instead, they looked at perceived lethality, military features, and mass shootings. They weighed these factors against Second Amendment rights. That's interest balancing, the exact thing the Supreme Court told them not to do. The plaintiffs argue this is practically indistinguishable from the old approach that Bruin rejected. Why this ruling is so dangerous. This Second Circuit ruling is one of the worst Second Amendment decisions in recent years. Think about what they're saying. They admit AR-15s are in common use. They admit they're used for lawful purposes, but they say none of that matters. According to this ruling, it's up to judges to decide which guns are too dangerous and can be banned. The common use test doesn't actually protect anything. This gives judges unlimited discretion. It makes the Supreme Court's guidance meaningless, and it opens the door for states to ban virtually any firearm they want. All they need is a judge who agrees the gun is dangerous. The appeal to the Supreme Court. The plaintiffs have now asked the Supreme Court to take this case. They argue that the Second Circuit's reasoning directly conflicts with Bruin and entrenches circuit court defiance of Supreme Court precedent. They also point to something Justice Kavanaugh said recently. When the Supreme Court denied review of another rifle ban case, Justice Kavanaugh suggested the court would address this issue in future terms. The plaintiffs are essentially saying, the time is now. If the Supreme Court doesn't step in, this defiance will continue. Lower courts will keep upholding these categorical bans based on their own discretion. The procedural complication. There is one complication with this specific case. It involves a preliminary injunction, not a final ruling on the merits. The Supreme Court typically prefers to review cases after they've gone through the full trial process. However, we have seen exceptions. The Supreme Court recently granted review to an emergency case in a similar procedural posture. So there's still potential for them to take this case. But there's also another factor at play. The other cases in the pipeline. 2 other cases involving rifle and magazine bans are also heading to Supreme Court conference. One is the Duncan case. The other involves a Vermont case out of Illinois. These cases are at the final merits stage, not the preliminary injunction stage. The Supreme Court will consider these cases at conference this Friday. If the Supreme Court grants review in either of those cases, it might put this Connecticut case on hold, or it might consolidate them together. But here's the risk. If the Supreme Court denies both of those cases, this Connecticut case will probably be denied too. The core constitutional question. Let's get back to the fundamental issue at stake. The Supreme Court in Heller clearly held that arms typically possessed by law-abiding citizens for lawful purposes are protected. They cannot be categorically banned. The Second Circuit said the opposite. According to them, even if a firearm is in common use, it can still be banned if judges think it's unusually dangerous. This completely nullifies the common use rule. It overrides Supreme Court precedent. The historical tradition allows bans only on weapons that are both dangerous and unusual. AR-15s are owned by tens of millions of Americans. Standard capacity magazines are owned by hundreds of millions. These cannot plausibly be described as unusual. By labeling commonly owned arms as unusually dangerous, courts collapse the constitutional test into pure judicial discretion. Why the Supreme Court must act? The petitioners argue that this confusion demands immediate Supreme Court intervention. We're seeing repeated upholding of bans on the most popular civilian rifle in America. Lower courts are defying clear Supreme Court guidance. The Supreme Court needs to clarify, does the common use test actually mean something, or can judges override it whenever they want? Justice Kavanaugh promised the court would address rifle and magazine bans. The time has come to fulfill that promise. What happens next? This case is heading to Supreme Court conference on January 23rd. As I mentioned, 2 other related cases go to conference this Friday. The outcome of those cases will likely impact what happens with this Connecticut case. We're watching the Supreme Court very closely. Will they finally step in and resolve this issue? Or will they let lower court defiance continue? The answer will determine the future of the Second Amendment and whether commonly owned firearms actually receive constitutional protection. Final thoughts. This case represents a critical moment for gun rights in America. A lower court admitted that AR-15s are commonly owned for lawful purposes, then said they can be banned anyway. That's not how constitutional rights work. The Supreme Court established a clear test. Firearms in common use are protected. Lower courts don't get to override that test based on their personal views about danger. If the Supreme Court allows this ruling to stand, it sets a devastating precedent. It means the Second Amendment doesn't actually protect the guns Americans most commonly own. We'll continue following this case and updating you as developments occur. The conference date is January 23rd. We should know soon whether the Supreme Court will take action. The stakes couldn't be higher. This is about whether the Second Amendment has real meaning or whether it's just words on paper that judges can ignore whenever they want. Stay informed, stay engaged, and remember, Constitutional rights only survive when citizens understand them and defend them.